Hello, good morning, good afternoon, or good evening, whether you're watching us live or if you're watching a recording. This is another session of the third Global Stop Cyberbullying Telesummit. We started on October 1st, so this ends it makes a week that we've been holding these lives every evening in Portugal. And by the way, my name is Tito de Moraes. I'm the author of a book called Cyberbullying, a Guide for Parents and Educators that was published in Portugal. And together with my co-authors, Luís Fernandes and Sonia Seixas, I'm the organizer of these sessions. Today, we'll be having an Italian guest, and I'll introduce him shortly. But before doing that, let us remind also what will be the subject. The subject will be cyberbullying, the Italian legal state of the art. So we'll be talking about legislation to prevent and tackle cyberbullying in Italy. And for that purpose, since I am not a legal expert, nor do I have a legal background, I have a Portuguese friend that is a lawyer. She's Marcia Lemos, and she specializes in family law, usually most of the time. So welcome, Marcia.
Hi, thank you, Tito. And good afternoon or good night to everyone who's listening to us.
Okay, so and Marcia, I'm talking from near Porto, which is the northern part of Portugal, and Marcia is from Coimbra, which is in the center of Portugal. And our guest, as I was saying, is in Italy. He's Rocco Panetta, and he's the managing partner of Panetta Law Firm and the EAPP Board of Directors member. Rocco is a tech and data economy lawyer admitted to the highest courts, privacy certified professional, managing partner, as I said, at Panetta Law Firm, chief operation officer and founding partner of Strand Privacy Technology Professionals, representing and working for domestic and multinational corporations, external DPO, data protection officer. Former top-level executive at the Garante, the Italian Data Protection Authority, from 2001 to 2008. Rocco has been Italy's representative at the European Commission within the activities of Article 29, now the EDPB. He is currently member of the board of directors of the IAPP, International Association of Privacy Professionals, as well as the IAPP Country Leader for Italy. Rocco has authored and edited more than 200 publications, including books, articles, and collections. Graduated at the School of Law of Rome University, La Sapienza, Magna Cum Laude, and specialized at the School of Law, University of Warwick, Environmental EU Law in the UK, and the London School of Economics and Political Science Management in the UK as well. Rocco has been the legal advisor of the Italian government on Ultra BroadBand and Internet. He is ranked amongst the leaders of Chambers Europe, Legal 500, TopLegal, Who's Who Legal, and he received the Legalcommunity TMT Award as the best privacy lawyer in 2015, 2018, and 2020. So welcome, Rocco, and thank you for accepting our invitation to be here with us.
Thank you, Marcia. Thank you, Tito. What can I say? I'm really glad to be here. Your event, this session, for the third time that you are organizing this great event, is really something that is inspiring people around the globe, and for each of us that in a given dedicated part of our professional life have done something for fighting cyberbullying, maybe now I'm much more a data protection lawyer, taking care of business data economy issues more than rights and how to fight discrimination. But in my past, and in my recent past, I was more focused on that. And for that reason, I would never stop to say thank you for what you do for the community and the society.
Thank you for accepting our invitation. So we agreed that we will be talking about the legal state of the art in Italy. And the idea is the session summary is increased use of digital communication technologies such as social networks by children and teenagers has brought to the arising of new unfortunate phenomenon called cyberbullying. You're one of the leading experts in the field applied to new technologies, and you illustrate the state of the art of Italian legislation in force with regards to such a phenomenon, mainly represented by the law number 71/2017, and we'll talk about that shortly, with a particular focus on the relevant aspects and the privacy perspective and the role of the Italian Data Protection Authority in the fight against cyberbullying. To start off, Rocco, how come did you got interest on the subject of cyberbullying? Or how did you got involved in cyberbullying cases?
That's a very good question, and it helped me to remind what I have done for a while in my professional career in my life. Everything started at university when I was lucky enough to meet one of the father of the the so-called privacy and data protection rights and discipline in Europe. I'm talking about Stefano Rodotà, the Professor Rodotà, that was one also of the father of the Charter of Nice, the basis for protecting fundamental rights in the European Union. And I graduated with him. So from a more, let's say, traditional perspective on law, I start focusing on fundamental rights, discrimination, and how to fight against discrimination and how to increase awareness of stakeholders at any level. Then, of course, I became a lawyer. I started working for companies, multinational corporations, but my interest remained over there. And when I joined the Italian Data Protection Authority, the so-called Garante, where I remained for 8 years as one of the head of legal, of course, my interest was shared amongst a number of issues, including how to fight discrimination. Then, under a professional point of view, I was again lucky enough to meet one of the leading European, let's say, worldwide cases that underline the importance of the awareness against cyberbullying. And I'm talking about, maybe later we will say something more, I'm talking about the famous case, the BV Down versus Google video cases. And I was amongst a panel of lawyers that was interested in this case, and I will say something later after the introduction.
Rocco, tell me something. We are aware that you have assisted TikTok, a famous social network, TikTok, in front of the Italian Data Protection Authority and EDPB. Is any major result adopted which deserves attention and you may share with us?
Oh yes, thanks for this question. This was probably the most recent case that I followed with some important implication on the cyberbullying matter, while the Google video case versus BBDown was one of the first case more than 10 years ago. So TikTok was really a surprise for each of us because, sometimes there's a lot of suspect versus towards the social media world. And instead we found a really, really open-minded company, very, let's say, interested in improving their processing. They realized that the Garante, the Italian Data Protection Authority, and the European Data Protection Board was seriously putting on the table a number of needs, a number of let's say requirements that at the same time would have been positive both for the society but also for their business. And if also a data protection authority let's say committed in the protection of fundamental rights like the Italian Data Protection Authority is, decided to withdraw the requests that previously the same authority had filed with the European Data Protection Board in order to adopt a binding resolution valid for all 27 member states, and the Garante decided to withdraw. They did it because the company was able to provide enough warranties in such improvements. And in concrete, what they do, they introduced a number of measures in order to block the access to minors or minors without the parental or outside the parental control, even with the help of some artificial intelligence mechanism. And the most important thing is that today, exactly today, October the 8th, the European Commission has recognized in its one of the recent press release that the increase in terms of reduction of abuse coming from the platform of TikTok has been measured equal to the 80%, which is a huge result in terms of, let's say, positive improvement of
Can I develop some about that question? As far as I recall, the problem that led to TikTok being blocked in Italy for a period of time was the case of a 10-year-old girl that that died as a result of seeing a video and doing what the video was instructing her to do. Do you think that that could have been there was the need for a 10-year-old to die under those circumstances, so that TikTok did something because they were blocked in Italy? If they were not blocked in Italy, would they have moved into put those measures into practice? It's speculation, I know, but
yeah. No, that's a very sensitive question, because involved a dramatic case that was that affected that was really felt by the public opinion in Italy, and as I see, considering that you are mentioning also abroad, I don't think that, you know, the information society players need exemplary cases in order to do something. The point is that there's too much fragmentation, even in Europe. I'm not talking about the United States or China, but if you think about what is happening in Europe, and we are the most advanced group of countries with the most advanced legislation protecting fundamental rights and fighting discrimination. And at the same time, we are victims of similar cases. We are assisting of similar cases. Unfortunately, these, let's say, enlargement of the market, including on a technology platform, more and more minors that are not under the control of someone, is a new problem, is a growing and upcoming issue. And sometimes, I don't want to be rude, but sometimes, unfortunately, this case needs at least to get an acceleration in the right direction.
Tito, let me say just this. Do you think the lack of parental control may lead to this too, to these unfortunate results with TikTok and other social networks? Is the state doing the part of the parents? They should be controlling their kids' access to these social networks and are not doing it.
Technology allows a number of things, including to have a sort of control, fine-tuning, in presence, by remote, by parental and or other adults having, let's say, a legal control on the mind.
Control.
So I don't want to be black or white here. There's not. When we talk about human behavior, there's always a lot of grays,
areas.
But at the same time, of course, the first actors, at least because they have legal liabilities under a certain nature, are the parents. And so they need to be aware of the technology, let's say, opportunities, but also issues. And the first lack of awareness or literacy is exactly that of the people of our age acting as a parents, and so people that should do this parental control. Then minors, of course, have to be also instructed, and they have to learn. But first, it's our community.
Okay.
Before we move to the next question, let me also make a comment related to that. It's not only parents actually that are victims. You have adults. I remember also in Italy, I believe it was a couple of years ago, a woman took her own life as a result of having intimate images of her exposed online. And this brings to the next question, which is, do you consider that the awareness and the level of prevention of cyberbullying in your jurisdiction and in the EU is enough?
No, it's not enough. And exactly what you say is correct, because of course we are talking about cyberbullying, which is mostly focused on minors, but the phenomenon is larger than that and includes, let's say, vulnerable people at large, including disabled or people with disturbs of various species of psychological or behavioral disturbs and so on.
Mental illness.
Mental
illness. But including the cyberbullying could also attack people that are supposed to be, say, in good shape or in business, because sometimes this is something that I prove with myself. Sometimes I control if my, let's say, reputational image on the web is in good shape, because I would probably suffer a lot in case of being attacked or harassed for something. I have 48. I'm 48 years old, so I'm not a minor. So the lack of protection is at various levels, but probably in our cases, in the cases of people outside the, let's say, vulnerable circle or the minors, the rules and the laws, the general codes of in the criminal code, in the civil code, or the GDPR itself, which is the law for the personal data protection, could be used in a quite effective way. The problem is that society is not aware of their rights, and also lawyers and judges are not properly aware about these means on how to fight the value.
You talked about
go ahead.
Sorry.
No,
you talked about a gray area for us lawyers, and I suppose for judges too. This is a gray area. We don't know much about it. There are not this many cases that turn out to be criminal suits, or that parents or even adults complain, and we are working with several laws, several types of crimes, and that's a bit confusing. Yeah, it's a gray area here. Yeah, you're right.
And do you think that also that magistrates and lawyers and prosecutors and whatnot should also have some more training on the limits of technology, what we can do with technology, what technology can do and what technology cannot do? Because I think that most of the times the problem is not a technological problem, is as you mentioned, a behavioral problem, right? And another thing related to that, and I'll pass the word to you, is do you think when we talk about the legislation across Europe and you look at GDPR and allowing, for instance, the age of consent to be for data protection to be between the ages of 13 and 16, and each country can do whatever they want, that doesn't make, it's not a union, it's a disunion, because each country has its own.
Yeah, absolutely. You're right. Just to reply to your first question, while I'm talking about Italy, but I think this could be extended in most jurisdictions, especially the civil law jurisdictions. While we developed in the years high specialized courts for a number of issues and disciplines, like the labor, like the, of course, criminal, and also for administrative litigation and so on. even for competition, we have a tribunal in Italy that are specialized, they have specialized sections to rule competition and antitrust cases. The GDPR related cases, which I consider the GDPR the milestone, the main rule to which we can attach a number of protection, has no specialized courts, has no specialized judge. So my case, your case, the case of the girls that killed herself, or the case of the baby, the kid that suicided herself after this game that she did online, have no specialized courts. And so sometimes it happened that judge just archive the case because they have no enough literacy, no enough competence. And probably that's also why I spend lots of my time also on a volunteer basis in order to teach people, in order to tell what I do, and in order to increase a little bit the awareness for those people that they will become professional.
They will search for information.
Exactly. And so the second, to reply to the second, your second questions on GDPR, yes, absolutely. We have so much fragmentation, and the GDPR is underestimated in what can bring in terms of protection, and especially because it's considered to rule only for privacy. This is a big issue that we have in Europe. I'm also representative and proudly representative, and I'm in the board of directors of this association that is called IAPP, which means International Association of Privacy Professionals. So I'm the first using the word privacy. That I always see that there is a big misunderstanding around what privacy covers, what privacy means. And so the result is that we maybe have the tools in order to increase protection in various fields, but the point is that people just underestimate the power of these tools. And so most of them tend to say, oh yes, privacy is nothing. Privacy doesn't match with the business, doesn't match with public administration, doesn't match. So they consider privacy as a word not linked with technology, with the use of data, and then with the life of each of us.
Yeah. You've spoken before about artificial intelligence tools applied to the social networks. With the increase of the use of artificial intelligence on the internet, the cyberbullying is increasing or decreasing? What do you think?
As you know, the technology is neutral, but it depends on how we can use in order to see different consequences. That means that the more, let's say, criminal use robots, artificial intelligence, technology, and software related to AI, the more we should do the same, because we could not pretend to protect people from this kind of massive criminal use of technology only with content moderators, with just psychologists interpreting the words that are used, or lawyers that are just intervening with the time, with the timing that they have in mind in order to reply to a request of maybe deleting or canceling something that is on the web. We need to use artificial intelligence in order to identify criminal activities. Where is the challenge? The challenge is not to give the final word to the artificial intelligence, not to abide to the role of the human beings in these activities, but to use in a smarter way the artificial intelligence, because otherwise our destiny is to go just in front of a big failure.
Okay.
But there is an issue there, isn't there, Rocco? Because privacy activists are claiming that using artificial intelligence to detect, for instance, grooming, to detect child pornography, and also to detect cyberbullying can be an infringement on privacy. What's your view on that, on the balance of protection of privacy on one side and the protection of the rights of the child to be protected on the other?
This is exactly the answer. My answer is exactly in the last part of your questions. Balance. You put in a balance the two values, the two rights, the two needs. We should remind that we do not have fundamental rights that are absolute fundamental rights. We have fundamental rights that need to be declined and measured from time to time with other fundamental rights.
Yeah.
This is the lesson that our constitutional fathers taught to us, and this is what we learned since we started our study at the university. Only people that doesn't want to understand this lesson says that, oh, privacy is a total and absolute right that has to fight against everything. No, because also during this pandemic period, we saw that the right of privacy and all the fundamental rights that are connected to the use of personal data have been, let's say, declined, and also now a bit compressed, now a bit expressed again from time to time, in order to also allow the protection of the health to be, put at the first place for a given period of time. We don't want to say that in order to protect the health and safety, we have to totally abandon the rest of the fundamental rights. No, the balance is the secret, and in balancing these fundamental rights is also not easy, but technology could help.
Do you think that we need more criminal sanctions or more education and awareness on the use of personal data online?
Before, in preparing a couple of ideas for talking with you today, I discovered that in Italy we have 11 criminal sanctions related to cyberbullying. We have other 6 criminal sanctions related to personal data processing at large, not only focused on on cyberbullying. And I could continue in order to list a number of sanctions. So we do not need to assist the proliferation of other criminals. As said, we need more education, and not only education towards, and just because we need to educate minors. The Italian Data Protection Authority just published, I don't know if you can see it, just published last week, this leaflet, this piece of paper with also a video that you can find on the website is www.jpbp.it of the Italian Garante. But it is clearly just a message addressing only, let's say, minors and their parents. The lack, again, is that this should also should address and speak the language, first, of all users, all category of users of social media and other internet services, because social cyberbullying is not only something that may happen within the garden of social media. This could happen also, in any kind of cyber experience. Also, they should invest, in my view, they should invest more in educating public authorities, public administration, policies, and no, you say is police body. Sorry, policies. And any other kind of, including judge, any other kind of regulators and courts.
So the law that is needed is a law mandating the education to prevent and tackle cyberbullying. That's the only law that is missing.
But
no sanctions, but a law mandating education.
I can tell you something funny here. When the GDPR was enforced, was enacted, implemented before the enforcement, the European Commission launched a number of programs at the European level called training the trainers. So in order to training people that in turn should be considered the trainers of other categories. And I was invited in Brussels due to my experience with these kind of authorities, to training the new also officials that were hired by the European data protection authorities after the implementation of the GDPR. Look, this is exactly what we should do in a massive way. We should invest and use a part of this PNRR, how you call the plan of recovery after the pandemic that was in Brussels, and especially in order to educate the educators, to educate the policymakers, to educate the judge.
Information is prevention, I think, and that's what we are talking about. But how do they react, judges, lawyers, policies, companies, parents, to that goal to train the trainers? Do you think they accept it well? In Italy, how did that work well? To inform, to learn, and the people accepted well the awareness of this?
Look, it's a matter of first, making the right law. Second, implement it in all European member states. Third, enforce in a proper way. If one of these three elements is not perfectly carried out and done, we will not succeed. But I can tell you that this is exactly what happened with privacy at a broader level. When I graduated in 1996. So exactly 1 year after the approval of the EU directive 9546, the directive on the data protection.
Yeah.
And so I'm a spectator and a candid spectator of the evolution and the growth of the data protection awareness across Europe. And I can tell you that if 25 years ago, when I started, the university were totally not aware of this phenomenon. Yeah. Sometimes it happened also that we were considered weird. No one of my generation, we studied with Professor Rodotà, that was one of the fathers. No one of our generation became professor at the university because there was no place for us at that time. Simply, now every university has a data protection, cybersecurity, privacy course, and blah, blah, blah. And the same happened with the law firm, and the same with my clients. When I resigned as a regulator and I set up my law firm, I did it because I felt when I was head of legal at Garante that outside there was a big need of professionals working on the ground and assisting companies and public administration in working well with personal data. And now, thanks to the GDPR, it is pushing a lot with this DPO role that sometimes is misunderstood. But the role of the DPO is changing the mentality of the company because the company has to rely to him or her, irrespective if the DPO, the data protection officer, is internal or external. There is a drop-by-drop exercise that is increasing the quality of awareness. And the same we should do with
cyberbullying. Is it a slow progression? Talking about cyberbullying.
Absolutely, yes.
Yeah.
The fact that in the last 10 years, the legislation changed. There was, at least in my country, a number of, let's say, statutes, law with the name of how to fight cyberbullying in terms of the scope of the law. This is a big first step, but it's not enough.
Mm-hmm.
Can you give us an overview of the legal framework currently in force in the Italian legal system regarding cyberbullying?
Yeah, absolutely. As said, we had a number of leading cases before the introduction of the law. One of these leading cases was the BV Down versus Google Video. Company Google Video is no longer exists because then Google bought YouTube, and so Google Video was shut down. And the case was quite famous because there was also a political international case. I remember that time Hillary Clinton, that was the Secretary of State of the United States, that says, oh, this Italian sentence because some Italian judge for the first time fighting against a cyberbullying case where a young man school was bullied and filmed, recorded at the same time. And then this movie was uploaded on Google. And then in a lack of a jurisdiction, no one did right steps in order to remove in a given proportionate time frame the video remains and remains and remains and was ad clicked for days. I'm using ad clicked.
Yeah.
Also, the idea that the number of advertisement and the investment
viewers
in video increased, and so a judge decided to take a look for the first time on that. And this judge, for the first time, says this is not only a case of, let's say, bullying and just a minor that is also a case of misuse of personal data. So the two legislation were linked for the first time, and this was very important. That, of course, the politician said something different. I remember Hillary Clinton saying the Italian leftish judge decided to go to do something against the United States. Yeah. And there's also the case that in Italy we do not have the judge under the control of the government. We have independent judge. Maybe they are not independent because of their own behavior, but there's not an appointment from the government. So it's probably totally wrong also the assumption. But at the end of this case, at the first instance, the Chief Privacy Officer of Google worldwide and the 3 members of the board of directors of the Google Italia were convicted. They received a condemnation for 6 months in jail. Then it was changed, and it was by the Supreme Court. It was changed the final rules, but this was a leading case in the country. 3 years after, the Parliament enacted this law, the law number 71 of 2017, which is the legislative framework on how to fight cyberbullying in terms of also how to react in case of any case that is, let's say, injuncted by a minor, assisted by the parent, by a parent, or by an association. So it was putting clear for the first time a procedure on how to react and defend himself or herself in case of a cyberbullying. For now, this law is still, of course, operating. I can say that it's just, let's say, it's not a standalone law because it's part of a framework, a regulatory framework, wider, including at the same time provision of the criminal code. I told you that I count 11 criminal
sanctions
article of the criminal Italian criminal code covering in a way or in another way the phenomenon of cyberbullying, and also with the integration with this Italian civil code and the possibility to claim for a compensation in case the author of the crime or unlawful behavior is identified. There's also the possibility to ask for a removal within the 24 hours by simply applying to the content provider. There's also the possibility to claim in front of the Italian data protection authority, the Garante, which can order a removal of an image or whatever within 48 hours. So we have a number of tools that could be used, and they are showing an interesting level of reduction, quote unquote, of some phenomena. We are still at the beginning.
Yeah, you almost answered something I was going to ask you. We know sometimes the legal system in Portugal is almost that way. We have several number of sanctions to against bullying and cyberbullying, but we know sometimes the practice, the cases that are torn out to criminal suits. Don't always go so well. What are in practice the safeguards provided by the law in order to protect the victims of cyberbullies?
That's really a good question. The first and most important safeguards and measure is may I use your motto, stop cyberbullying. In other words, to stop the source of unlawful behavior. It could be, because that's also why, before I say it, that the criminal tools are not always the good solution.
The good solution, yes.
The cyberbullying not in all cases lead to a criminal case, and we should be able to detect the cyberbullying behave even before that these could become a criminal case. And so even the unlawful contact, the unlawful, which could let's say be in breach of personal data rights and freedom, or other ethics, maybe conduct. Think about the cyberbullying in a school, where sometimes the activities are, of course, carried out online, that in a context that far from a criminal set, is a context between scholars, between students, between minors.
Yeah.
So it's very hard to understand that. That's why the first safeguards, and the one that I would emphasize, is the removal of any source. And we should be able enough not to fall in the mistake, or in the mistake of considering sometimes to remove
content, a piece of content.
Exactly, as a behave against the freedom of speech.
Of expression.
Yeah.
This is probably one of the first points. And that's why the obligation to remove by the request of the victim is a must.
Yeah.
And that's also why the Data Protection Authority is insisting the law.
And the time frame in which that removal happens is also crucial.
Yeah.
Because if you do it in 24 hours, the damage is more limited than if you do it within a week.
Yeah.
So a
That's
time
very
frame
important.
is crucial.
And especially because in that way, you may avoid a commercial use.
Exploitation, yeah.
Exploitation of the.
Absolutely.
The more you click, the more the content could
is viewed. Yeah.
And
as you mentioned, in the case of the Google video case, in which the video was exploited commercially by showing ads, that somebody profit from that,
Exactly.
and it's regrettable.
What most network are understanding, because they are understanding that sometimes the mere quantity of the content is not matching in all cases, especially in Europe, also with the retention of clients. They should retain clients and or users, and in doing so, they should understand that we pretend the respect of our fundamental rights.
Marcia.
Sorry.
No, I was going to say that the time lapse in which the image or the video is online, it is, and the tool to remove that image or that video from the internet or the social network may also prevent, and sometimes may also do another effect. I will think before I put a video online, knowing that in 1 hour, 10 hours, 24 hours, it will not have the effect I wanted with it. So it's prevention also of doing something wrong. We know it's wrong, but it's another tool to prevent that.
Absolutely.
And that's why you can one can put in place also some measures thanks to the technology itself, because we can put some barriers, some filters, some now it's a fashionable way to say artificial
intelligence. Yeah. Some filters. Yeah.
Exactly.
Okay, Rocco, we're reaching the end of our time, so I have one last question. What is the role of the Italian Data Protection Authority, the Garante, in fighting cyberbullying, and more generally in protecting the rights of children related to the use of new technologies? Is it limited to the age of consent only?
No. Thanks God we have the Italian Data. They are, I say they because I don't want just to say the authority in terms of the chairman or the board, but I'm addressing all officials, directors, my former colleagues, and I know that they are all committed to protect the rights of all citizens, all individuals, but with a special focus on the minors. And this was an important, a very important, let's say, must in their commitment. Unfortunately, the problem is that this is also a source of being upset. We see that notwithstanding the role of the Data Protection Authority, notwithstanding our constitutional civilization, say, the people that are the legislators and also some stakeholders and also journalists, they suffer a lot. The presence of an authority that could have such an important role, and they are not providing any kind of economic support. They are not providing new human resources. When the authority says something in the journals and the public opinion, there's a fighting against what the Garante says because privacy. Nothing. We should think about the economy, how to recover. This is not good. This is not good because it's not providing the right support to an institution that is doing a lot. Is the only one that is doing something in order to put at the center of this technological revolution the human beings. And that's why we should always support the action of our data protection authority.
Okay. Marcia, I don't know if you have any question, but if you do, please ask, because I have to introduce the session for Monday. And
Okay.
one final question for Rocco, which will be to give us some tips or recommendations. So, do you have any questions?
No, I don't have. I was glad to know that the Italian system, legal system, is a bit like ours. But I'm glad to know also that you are doing excellent work, providing us tools to work here in Portugal also with the data protection and with the cyberbullying, and that idea of forming and informing lawyers, judges. I think I will guard that idea to think about it and to implement it here too. Thank you, Rocco.
Thanks a lot. In terms of tips, Tito,
yes. Before the tips, can you tell us something about Strand Advisory, data innovation, data strategy, and data privacy? It's a group that I know that you are involved and helped form.
Thanks. This question is unexpected, and I'm glad that you are telling me. Our last, let's say, creation. We understood that. When I said we, I mean me and a number of other, let's say, data experts around the globe. We understood that probably now the world is plenty of data protection or privacy lawyers or other kind of specialists. That the thing that probably was missed is this kind of professional experience in different fields. As we showed today, we were discussing about rights, but at the same time needs of companies or public administration and so on. So this Strand Advisory, which means how to advise in order to get straight to the point, has this ambitious to introduce some ethics in whatever we do with consulting in the data and related data economy strategies. In terms of tips for you, I have just one. Please keep it on. Continue to doing what are you doing, and I'll hope to see you next year for the 4th cyberbullying.
Yeah, for sure. You'll help us out in finding another Italian guest, I'm sure. So let me just say that Monday we'll have Elizabeth Milovidov. She's also a lawyer. She's originally from the US, but she's been living in France for a very long time. She's been working with an organization called e-Enfance, and she'll be talking about her experience within that organization on the topic of bullying, racism, and online harassment. That's at 9:30 p.m. Lisbon time, 10:30 Paris or Rome time. Rocco, huge thank you for accepting our invitation. It was a pleasure to have you here with us and learn a bit more about the Italian legal framework regarding cyberbullying. Regarding Strand Advisory, you need to find a partner in Portugal.
Yes.
And I wish you all the best. Let's keep in touch. And if you need anything from us, just give us a shout. Thank you very much.
Thank you
for being with us.